Peace and love, everybody. Just wanted to give you an opportunity to check out this book by LexisNexis, produced by LexisNexis. All right, these guys are pretty damn good. They're leading, law information, law research, and practice and procedure. All right, and not just in the state of Florida, but throughout the whole corporation, United States of America. All right. So I just wanted to just take a second to just show you one section of this book, all right? Now, I'm in chapter 8.8, chapter 8, which regards to search and seizure. All right, now if you look at this section 8.53, well, let's look at 8.52. Grounds for a traffic stop. A traffic stop is a Fourth Amendment intrusion and must meet the reasonableness requirements of that provision. Therefore, an investigatory stop for a suspected criminal traffic offense will require the usual reasonable or founded suspicion. A stop for a civil traffic infraction may be made upon a showing of probable cause. An officer has reasonable suspicion to stop a vehicle when a request to find out the status of a vehicle's tags yields a no record found result. An officer had legal. Oh, too excited. Too excited. There we go. Let's see. An officer had legal basis to stop the defendant's vehicle due to partially obscured expiration date on the car's license tag. So make sure if you drive in a vehicle, if you're traveling, and you have corporate tags on it, make sure that your trust is paying the proper fees to the state, and keeping those things up to date, because you don't want any violation of your trust property. All right. Other things to consider: 8.53, conduct removing an occupant from a vehicle in duration of the stop. The Fourth Amendment does not prohibit an officer from removing a driver from his car during a traffic stop or rendering the driver to remain in or return out of the vehicle. However, ordering a passenger back into a vehicle is a significant restraint on the passenger's freedom. The rule is that a stop for a traffic citation may last no longer than the time it takes to write the citation. There must be a valid consent, and if consent is clearly not provided and there is no further reason to detain the suspect, then it may be an illegal detention. Where a defendant was stopped for suspension of DUI, was determined not to be intoxicated, and subsequently refused consent to a search of his cars, drugs discovered by K-9 unit were the fruit of an invalid detention. Once the defendant was determined sober, there was no longer any lawful reason not to let him go. To that end, the police may not continue a lawful detention after the reason for the detention has been resolved. That's powerful stuff. That's powerful information, ladies and gentlemen. Strongly, once again, suggest you check out this book. They've got some great information in it. Once again, I was just like thumbing through at my local law library, came across this book. Local, criminal procedure, Florida criminal law, 2017. This is up to date. Don't get no more accurate than that. All right. Combine your Moorish sciences or your other forms of research with what the state has already got and beat them at their own game. All right. You want to include stuff on like where you come from and what you're doing? Hey, do that, but it's not really necessary. So what's necessary is making sure that these officers of this system are acting, or acting within their given responsibilities and position of authority. All right, delegated authority. So peace and love. Oh, also, let me just not a lawyer. This is just only a suggestion for your education, information, and maybe a little bit of entertainment. Peace.